Good morning, everybody, and welcome to the Office of Equal Rights New Employee Orientation. My name is Glenn Padiachi with the Office of Equal Rights. I am the Equal Employment Opportunity, Diversity, and Inclusion Training Specialist. Happy to be with you this morning and today we're going to cover EEO retaliation, and we're going to talk about that and kind of really get into what does that mean for you as an employee. All right, so first of all, EEO retaliation is unlawful under Title VII of the Civil Rights Act, and it violates FEMA's EEO policy. It occurs when an applicant, an employee or anybody closely associated with these individuals are engaged in a protected activity and they are treated less favorably, meaning that they are subjected to some type of employment action, a negative employment action, because of the engagement in a protected activity. All right, so let's talk about a protected activity. Here are examples of what a protected activity is. If you as an employee go into the Equal Rights Office and file a complaint or notify them that you've been subjected to harassment, that is a protected activity. Reporting discrimination or harassment is a protected activity. Participating in a discrimination interview, investigation, or lawsuit, for example, serving as a witness, representing an individual through the EEO process, that's considered an EEO protected activity. Opposing discrimination. Let's say that you think that there's unfair hiring practices or there's discrimination, racism in a certain particular program area, and you make that known. Well, that's a protected activity because you're opposing an unlawful discrimination conduct. And then, of course, if you are requesting a reasonable accommodation, it's considered a protected activity. So the federal law protects employees from retaliation from employers and managers who internally or externally complain about discrimination or harassment. Managers and supervisors are not allowed to do anything in response that would discourage a reasonable person from filing an EEO complaint. So we want to ensure that there's no harm taken against individuals because they've filed an EEO complaint. And retaliation still exists even if the allegation that they're complaining about is proven to be untrue or not founded, but as long as it was done in good faith, it's considered all right. Oops. All right. Examples of adverse employment actions or harms could be a reduction in pay, denial of training, demotion, demobilization, change of your work location, poor job evaluation, failure to hire, or even termination. That means that because you engaged in an EEO protected activity, because you filed a complaint, your manager did one of these things to you to punish you for your reporting discrimination or for your engagement in one of those protected activities, right? So in order to show cause for EEO retaliation, we must show that an individual, an employee has engaged in protected activity, that they were subjected to an employment harm that we talked about, any action or employment decision that adversely impacts terms, conditions, and privileges of employment. And lastly, a causal connection. That means that because of your engagement in a protected activity, you incurred an employment harm. And to help us with that, to make the causal connection, we look at temporal proximity and knowledge. All right, and if you believe that you've been subjected to EEO retaliation, we encourage individuals to file a complaint, and you can inform your management, local ERAD, call the Office of Equal Rights, or by email. Do we have any questions on EEO retaliation?